The beginnings of Roman law. Within this unique constitution, the magistrates administered a system of law based upon the 12 tables of the decemvirs. Before that epochal enactment, Roman law had been a mixture of tribal customs, royal edicts, and priestly commands. Mos Maiorum, the way of the ancients, remained to the end of pagan Rome the exemplar of morals and a source of law. And though imagination and edification idealized the ruthless burghers of the early republic, the tales told of them helped educators to form a stoic character in Roman youth. For the rest, early Roman law was a priestly rule, a branch of religion, surrounded with sacred sanctions and solemn rites. Law was both lex and jus, command and justice. It was a relation not only between man and man, but between man and the gods. Crime was a disturbance of that relation, of the pax deorum, or peace of the gods. Law and punishment were, in theory, designed to maintain or restore that relation and peace. The priests declared what was right and wrong, fas et nefas, on what days the courts might open and the assemblies meet. All questions regarding marriage or divorce, celibacy or incest, wills or transfers, or the rights of children, required the priest, as now so many of them require the lawyer. Only the priest knew the formulas without which hardly anything could be legally done. They were in Rome the first jurisconsulti, consultants in the law, counselors. They were the first to give responsa, or legal opinions. The laws were recorded in their books, and these volumes were so securely guarded from the plebs that suspicion charged the priests with altering the texts on occasion to suit ecclesiastical or aristocratic ends. The 12 tables effected a double juristic revolution: the publication and secularization of Roman law. Like other codes of the 6th and 5th centuries, those of Charondas, Lycurgus, Zaleucus, Solon, they represented a change from uncertain, unwritten custom to definite written law. They were a result of increasing literacy and democracy. The jus civile, or law of citizens, freed itself in these tables from the jus divinum, or divine law. Rome decided not to be a theocracy. The priestly monopoly was further deflated when the secretary of Appius Claudius the Blind published 304 a calendar of court days, dies fasti, days of utterance, and a formulary of proper legal procedures which had till then been known to few but the priests. Secularization took another step when Coruncanius, 280, began the first known public instruction in Roman law. From that time onward, the lawyer replaced the priest and dominated the mind and life of Rome. Soon, the tables were made the basis of education. Till Cicero's day, all schoolboys had to learn them by heart. And doubtless, they had a share informing the stern and orderly, litigious and legalistic Roman soul. Amended and supplemented again and again by legislation, praetorial edicts, senatus consulta, and imperial decrees, the 12 Tables remained for 900 years the basic law of Rome. The law of procedure was already complex in this code. Almost any magistrate might act as a judge, but the praetors were the usual court, and their revisions and interpretations of the statutes kept Roman law a living growth instead of a corpse of precedents. Every year, the praetor urbanus, or chief city magistrate, drew up a list or white tablet, album, of senators and equites eligible for jury service. The presiding judge in an action chose jurors from this list, subject to a limited number of rejections by plaintiff and defendant. Lawyers were permitted to advise clients and plead in court, and some senators gave legal advice in public sittings or at home. The law of Cincius, 204 BC, forbade taking pay for legal services, but legal skill found ways of circumventing this counsel of perfection. Slaves were often tortured to elicit evidence. The 12 Tables constituted one of the severest codes in history. They retained the old paternal omnipotence of a military agricultural society, allowed the father to scourge, chain, imprison, sell, or kill any of his children, merely adding that a son thrice sold was thereafter free from his father's rule. Class division was preserved by forbidding the marriage of a patrician with a plebeian. Creditors received every right against debtors. Owners could dispose freely of their property by will. Property rights were held so sacred that a thief caught in the act was given as a slave to the man whom he had robbed. Penalties ranged from simple fines to exile, enslavement, or death. Several took the form of equivalent retaliation, lex talionis. Many were fines delicately adjusted to the rank of the victim. For breaking the bones of a freeman, 300 asses. Of a slave, 150 asses. Death was decreed for libel, bribery, perjury, harvest thieving, nocturnal damage to a neighbor's crops, the defrauding of a client by a patron, practicing enchantments, arson, murder, and seditious gatherings in the city by night. The parricide was tied in a sack, sometimes with a dog, a cock, a monkey, or a viper, and cast into the river. Within the capital, however, appeal from any but a dictator's sentence of death could be taken by a citizen to the Assembly of the Centuries, and if the accused perceived that the vote there was going against him, he was free to commute his sentence into exile by leaving Rome. Consequently, despite the severity of the 12 Tables, capital punishment of freemen was rare in Republican Rome.